Thank you, Mr. Speaker. It is my pleasure to rise today to talk about Bill C-17, an act to amend the Yukon Environmental and Socio-Economic Assessment Act and to make a consequential amendment to another act. To be honest, this bill is regressive. It reverses several positive steps taken by the former Conservative government in Bill S-6. That was done in 2015. It is a poorly conceived piece of legislation which, if passed, will gain votes in southern part of this country at the expense of northern Canada. On October the 3rd, we heard testimony at the Indigenous Affairs Committee from a Mr. Brad Thrall, who is the president of Alexco Resource Corporation. He summed the problem up best, I think, Madam Speaker. He said, "I'm urging deferral of Bill C-17's passage until all affected and interested parties can deliberate and mutually determine language to preserve the reassessment and timeline provisions currently within the Yukon Environmental and Socio-Economic Assessment Act. Repeal of the reassessment and timeline provisions as anticipated in Bill C-17 without replacement language ready to go will perpetuate economic uncertainty and will negatively impact the competitiveness of Yukon and will diminish economic and social opportunities for all those Yukoners. Why would we want to pass legislation that will diminish economic and social opportunities, especially in the north? The population of Yukon, according to the last census in 2016, was just under 36,000 people. It's a small jurisdiction then. And so you can understand that the benefits and opportunities of one operation can have tremendous benefits for First Nation and all Yukon residents in terms of tax dollars, in terms of health care, in terms of education, employment, and benefit agreements. The mining industry contributes 20% of Yukon's GDP, and Bill C-17 would immediately increase the regulatory burden on proponents. It would slow down the review process by increasing the number of projects that need to be reviewed and removing the timeline for approval. Mining representatives testified that over the past 8 years, the time period required to deem our project proposals adequate was increased more than 5-fold. Removing the timelines put in by the former Conservative government will damage proponent and industry confidence in the regulatory regime and cause companies to take their investment elsewhere. And it's already happening, Madam Speaker, in this country. The Prospectors and Developers Association told us they have definitely seen a decline in investment in Canada the past 2 years. And if you don't believe me, just look at what Shell did with the Carmen Creek project in Alberta. It was an investment roughly of $2 billion. Shell sold the assets in Carmen Creek while going to Europe, citing a more stable investment regime in that country and that area compared to one in Canada. This was a major opportunity lost, not only for the people of Alberta, but for the people of Canada and the people of northern Alberta. Mr. Thrall went on to testify at our committee on October the 3rd that the current legislation allows proponents of certain projects to apply to decision body, usually Yukon or First Nation governments under Section 49.1, to allow the project to proceed without the need for reassessment. This allows previously assessed projects to proceed to the authorizing process without duplication. As we all know, the reality of mining is that during the process, new or extensions to existing ore bodies may be identified, and these discoveries may require slight modifications to mine operating plans under the current legislation. While these modifications would generally not require a complete project-wide reassessment. However, if this bill, C-17, is passed, they would, even though there is no significant environmental or socio-economic impact and no change in the production stream. Mr. Thrall went on, and he continued on October the 3rd, on the environmental side of our business, we are required to go back through an entire environmental assessment to maintain a water license to extend the operating period for various water treatment facilities. Now, ironically, these same facilities were mitigating historic environmental liability, but this simple extension required 134 days of YESIP's time to assess the entire project yet again. So please understand that we firmly support a rigorous environmental assessment process for the Yukon. For new projects, when fundamental changes are made to existing projects, however, small changes to a mine plan or environmental facilities should not require back to square one assessment. If set back to the previous legislation, uncertainty will prevail, and investment, the jobs, the benefits, and the opportunity for residents and communities will then be compromised. This is just another example of the Liberals making promises without thinking of consequences. The Liberals could have worked to find a solution addressing everyone's concerns rather than rushing forward and choosing to handicap the Yukon's development for years to come, possibly even decades. Then we had Mr. Jonas Smith, the project manager, Yukon Producers Group, and he gave a compelling testimony to our Indigenous Affairs Committee on October the 3rd of this year. His focus was on the matters of reassessment. Mr. Smith explained the burden which will be placed on industry, municipalities, and all Yukoners by Bill C-17. He told us the absence of a reassessment provision will not only negatively affect proponents, but places a strain on the financial and human resources of publicly funded assessors and governments as well. Another very recent example from a Yukon mine ramping up to production revealed that in the last few months, when the bill C-17 has been making its way through Parliament, the company was once again subjected to an expensive, time-consuming, ultimately unnecessary reassessment. In this case, YESIP ultimately determined that reassessment and any further mitigation beyond the original assessment were not required. Yet, despite this relatively favorable outcome, the process that led to it still consumed considerable resources from the company and YESIP's assessment office. More delays. It resulted in a missed season of work for that company up north, where those financial and even human resources could have been put to far better use, employing the citizens of the affected First Nations and the community where it operates. As I mentioned previously, since Section 49.1 was enacted in 2015, over 100 projects have applied for exemption from reassessment. These were not only mining proponents, but municipalities as well. The City of Whitehorse, a major employer to the territory's capital, received this determination under Section 49.1 for one of its permanent renewals. The project had been assessed once by YESIP back in 2013. Now, since that time, only changes in relation to the project were minor and regulatory in nature, but there has been no significant changes to the project, and therefore an assessment really was not required. It has been suggested, given the number of Yukon's economic sectors that have benefited from this reassessment provision, including industry and municipalities, that removing it before its replacement is in position is like ripping the roof off your house before deciding what to replace it with and leaving, in this case, the Yukoners out in the cold for the rain and the snow in the process. Well, Yukon's mining industry is modern, it's responsible, it's innovative. It is a partner at the forefront of research and relationships that balance economic, social, cultural, and environmental values. And it and its supporting service and the supply companies are our territory's largest private sector employers. It contributes, like I mentioned, Madam Speaker, 20% of the GDP, a significant number in a small developing jurisdiction of just under 36,000, otherwise dominated by the public sector. The mineral industry is committed to working with all orders of government to provide opportunities that allow Yukoners to grow up in the territory, to study, to train in the territory, to pursue rewarding and well-paying private sector jobs and careers. In closing, Mr. Smith added on that October 3rd meeting, in conclusion, he said, Madam Chair and two committee members, the Yukon Producers Group proposes that a committee of interested and affected government and industry parties be struck to work on the replacement for the reassessment and the timeline provisions and provide its recommendations for this replacement before the bill C-17 receives royal assent. If replacement provisions are not in place beforehand, industry, municipalities, and all Yukoners will suffer. Mr. Burke, the president of the Yukon Chamber of Mines, told us the following on October the 3rd. I would like to draw your attention to Minister Bennett's commitment in a letter to the Yukon Chamber of Mines, which was dated July 6th of this year. Once amendments to Bill C-17 have been made, the department then is willing to work with Yukon First Nations, the government of Yukon, and stakeholders such as your organization to review these issues in order to identify possible short-term administrative or even long-term legislative solutions. Well, we appreciate that commitment. However, it is imperative that all orders of government work to undertake and implement solutions to these issues in advance of the passage of Bill C-17 to ensure continuity for all parties involved. The time to start this work is already in the past. Our concerns for the future of business have been shared with all levels of government. We strongly urge you to begin this work and establish a timeline to report progress on this front. Mr. Burke went on to tell us on that meeting on October the 3rd here that the Yukon Chamber of Mines and our membership support the need for a robust environmental review process. We represent a science-based industry composed of geologists, composed of engineers, tradespeople, and other professional and non-professional occupants. And this has made and will continue to make significant investments in reducing the impact of our business has on the environment. We do not want to save money at the expense of the environment. This is a myth. So let's talk about this again. We do not want to save money at the expense of the environment. That is a myth. We are at the forefront of reconciliation, and we invest in the backyards of Yukon First Nations. We are at the forefront of reconciliation as we partner with Yukon First Nations and provide economic opportunities where, in many cases, as we know, few other opportunities exist in the private sector in this country. We support the passage of Bill C-17 in order to reconcile with Yukon's First Nations. We urge the federal government to immediately engage with the First Nation governments and the Yukon government to find short-term administrative, or as I mentioned, long-term legislative solutions to the impact of the removal of the reassessment and the timeline contained in the Bill C-17. The impact of the bill C-17 without addressing these concerns will have a serious negative impact on investment, mining, and exploration projects in the Yukon. The Yukon Chamber of Mines urges that this work be undertaken to implement solutions to these in advance of the passage of the Bill 17 to ensure continuity for all those parties involved. The government has claimed that all stakeholders are 100% behind Bill C-17. Well, that's simply not true, Madam Speaker. The support was not an unconditional rubber stamp. In fact, the support is contingent on what has been promised by the now Minister of Indigenous Affairs and Northern Relations. They emphatically told the committee, and I will quote, "The federal and territorial governments must work immediately with First Nation governments to address the concerns and risks associated with the removal of the provisions addressing the reassessment and timelines from the Act." I will reiterate the commitment the minister made to the Yukon Chamber of Mines when she was up there in July. She wrote, "Once amendments to Bill C-17 have been made, the department then is willing to work with Yukon's First Nations, the government of Yukon, and stakeholders such as your organization to review these issues in an order to identify possible short-term administrative or long-term legislative solutions." I hope the minister is listening to what stakeholders are telling her. We had 3 excellent people that came to our meeting on October the 3rd to address this situation. But you know what? That was back in July when the minister addressed these concerns in the Yukon. So now we're into November. The months have passed. All stakeholders, including Yukon First Nations, are ready to collaborate to ensure the regulations have something in place to address these major concerns. But the minister's office, how surprising, remains silent. Madam Speaker, it's imperative that the minister follow through on her commitment that she made in July and do so very quickly. Bob McLeod, who is the Premier of Northwest Territories, told the Arctic Circle Assembly on October 13th, a month ago, the people of the Arctic want what everyone else wants. They want good jobs, Madam Speaker. They want a good standard of living. They want to be healthy. They want to be educated. And most of all, they want a sustainable future for themselves and for their families, based on their own vision and their own priorities. Thank you, Madam Speaker.